Okay, we're going to call the Thursday, October 17th, 2024 City Charter Review Committee to order. We have with us Asia Sim, who is going to be the one taking minutes today from the city. Thank you, Asia, for coming. If you would please call the roll.
Diane Caderas,
Present.
Pam Wheel,
Weil. Present.
Jonathan Foreman,
Present.
Jeffrey Hank,
Present.
Veronica Wilkerson Johnson,
Present.
Ruben Martinez,
Here.
Jill Brody,
Here.
Dale Ruthoff.
Yeah.
Is that everyone? My list is out of order, sorry.
Okay, our first item is 1.2 approval of the agenda. I'll move approval of the agenda. Is there a second?
A second.
Moved by Cadera, seconded by Wilkerson Johnson. Any additions or corrections? If not, all those in favor say aye. Aye. All those opposed, same sign. Okay, 1.3, approval of the minutes from the City Charter Review Committee of October 17th. Is there a motion to approve?
I still move.
Moved by Wilkerson Johnson.
Second.
Seconded by Foreman. Any changes or corrections to the minutes?
I have, it doesn't reflect not really any of the oaths, but I'm all for it now, that's all the conversation, but we talked about the affirm or swear. And there was a discussion that we were saying or swear in our verbal, that the clerk was saying, but that it wasn't in any of our documented oath. I just want to make sure that.
So I'll move this. Mr. Bellman, to be put under, right before old business, the last line, under sample oaths and Asia,
Fresh one.
Asia, I printed this, I wrote this out, I'll just give it to you so you don't have to say it on. But I move that we add Mr. Bellman, city manager, to follow up with clerk to make sure oaths are taken consistently and printed that way to include the words swear or affirm text. There a second?
Second.
Seconded by Wilkerson Johnson. Any discussion on that change? All right, anything else to the minutes? Okay, all those in favor, say aye.
Aye.
All those opposed, same sign. The minutes are approved. Okay, then moving on to communications from the audience. We didn't have anything in our packet other than the emails that were sent from the committee members. There's nothing from anyone else not on the committee. Dana, did you have anything that you'd like to say?
Yeah, respecting.
And Nixon has a microphone right behind him. You can't see it right now.
Am I timed? No,
As long as you need.
I'm not. Gotta go shopping. And the mall closes early. Can you guys hear me? Can you hear me?
Get it. It's not on.
Oh, there's not a
Oh, I have it.
turns.
Small.
Oh, I see it.
There we go.
Hello, everyone. My name is Dana Watson, serving currently on East Lansing City Council, and my pronouns are she, hers. First, I want to say thank you all for serving with us. Welcome. I look forward to the recommendations because typically if something sits for too long and the policy is not updated, it's not keeping pace with changes in society or nation or so the big part of what I wanted to talk about today was 7.12 that talks about nepotism. I served on East Lansing City Council when it was brought to our attention to update what we had written in regarding nepotism or to have something written in on nepotism, which we did. But unfortunately, we missed the mark in some spaces. So 7.12 talks about paid relatives. And we missed the mark because we did not cover appointed commissioners. And I am bearing witness to the problems that occur when we appoint in this instance, someone else's spouse to one of our commissions. Now, first of all, I want to say I'm a mother of 3 kids, And when I agreed to this nepotism policy, it also left out my children's opportunity to just get paid to work on the parking force or at Hannah Community Center. And I'm not here to make a big stink about that. It's unfortunate, City of East Lansing is close for us, but the problem as far as when we're thinking about transparency that we want to show to the community, we've lost that because we missed the mark on nepotism by not including appointed commissioners. I have been serving on city council since 2020. And I began on the Human Rights Commission in, I think, 2015. And so I'm currently council liaison for East Lansing Independent Police Oversight Commission, our Human Rights Commission, Transportation Commission, as well as Housing Commission, and also CDBG Advisory Board. Before I was appointed to City Council, I served on the Human Rights Commission and the Planning Commission, and also on the CDBG Advisory Commission. And prior to my new commissions, I've also been council liaison for the Historic District Commission. I have never seen anything take place the way it has because of the appointment of a city council member's spouse on our East Lansing Independent Police Oversight Commission. Been in conversations with Attorney Chubb, Mayor Brookover, Councilmember Meadows regarding my concerns. I'll cite one story and I can, I'm happy to talk more about things. It is my belief that because of a person's privilege as the spouse of someone on city council, they got a public meeting canceled on their own. It was a public meeting that was to occur on a Saturday where this person agreed to be a speaker. Unfortunately, there was no agreement, there was no pay, and there was no physical contract on what the expectations were. This person decided that because they didn't feel that outreach was done appropriately, and mind you, outreach was done by the same city staff person who does our outreach for our Human Rights Commission, who hosts a coffee and conversation on a monthly to quarterly basis. And so my assumption there is she knows what she's doing. And we've never landed at, oh, our coffee and conversation, the crowd wasn't big enough, or a chair or anyone could say, I'm concerned about outreach, and they go ahead and cancel the appointment. As a council person, I can't call Mayor Brookover and get an open meeting canceled on my own, but this person was successfully able to do that. And I believe that she was able to do that because she sent information only to the staff liaison and the city manager about her concerns, despite that our East Lansing Independent Police Oversight Commission as a whole voted on this hearing or this meeting and voted for it to take place. She went around the chair and co-chair. There was no conversation, and she had our staff liaison as well as our city manager running around trying to accommodate her, to cancel it, to check on new dates. And again, I've never seen that before. And I tried my best when we appointed this person to have an open dialogue with council members about transparency, that we would make real efforts to be transparent because it's sensitive and it does lean into possible nepotism. And that's what occurred. And another example is communications. I'm co-council liaison on East Lansing Independent Police Oversight Commission. That means 50-50. It doesn't mean 60-40. It doesn't mean 49-51. So the expectation is if communications are made to a council member, that I'm receiving those same communications. And that's not what happened in this instant. Councilmember Meadows was the only person that knew of the cancellation. And I know that because I circled around and called him, because that's how I do work with council members. And he already knew. And I was like, well, why do you think this commissioner didn't reach out to me too? Why didn't they reach out to the chairs? And he gave an answer. But what I'm saying is, I believe that the problem is we missed the mark when we talked about nepotism and paid position, and we didn't talk about the problems of appointing relatives. And this is, again, over age 18, because I also want to mention that former Councilmember Garcia's sons serve on the Youth Commission. But that's not where I'm saying the problems are. Those are young people. The next thing I want to talk about. Oh, any questions or anything? Any questions or comments?
Well, could there be bylaws for the committee around a communication plan? And the fact that if any changes are made, all the committee members would be notified by the city manager or staff? Is that the kind, could that address this sort of issue?
I think what addresses it is that we're no longer in a space where we have to consider people that are related to other people that are serving on East Lansing City Council.
Well, I know I've had experiences on the Parks Board where there's just a powerful personality that goes directly to, for other legacy, I don't, you know. For other legacy.
But it's like, why did they jump so fast and hard? And I believe it was because of the individual that was sending the message. And I also want to say that our chair and co-chair, we will let you know, they rarely were receiving communications from city manager, acknowledgements from the city manager, let alone action solely taken. Typically, you get that type of information from a commissioner, not even chairperson, and you circle them back to that commission to have that discussion, or you circle people in. But I believe because of the privilege that this person had, that they thought they had to do something different. And it becomes uncomfortable for Councilmember Altman. While I don't agree with him, a lot of the time, I understand that he is a council member alongside me. And so communicating with him and saying, hey, are you gonna not participate in a conversation or opinion because your spouse is on East Lansing Independent Police Oversight Commission, and it becomes messy. And I don't think we'd be there if we had tidied it up a little bit around nepotism. I think I saw somebody's hand.
That was me. Thank you, Councilwoman Watson. So the problem is more so with appointed positions, not with paid.
Oh, we got it right with paid, but we should have added appointed positions as well for spouses or relatives over the age of 18. And if you all are watching what's going on in the suburbs, Meridian Township, East Lansing, we are seeing spouses and step relatives uplifted in ways that we haven't seen before. And then it becomes questionable and problematic. And we want to operate transparently. We want to operate in a way that someone doesn't have special sway because they're related to someone. Meridian Township's Meridian clerk that was recently elected is the stepdaughter of someone who, from what I understand, didn't have that much experience, as well as Senator Sting, who sent out a letter to all constituents asking us to vote for his wife. And it crosses those lines. Not that the charter takes care of this, but what it does take care of is the questions that the community has and the people that come to me saying, this was it's problematic when we do this to our commissions.
What would this wording address the communications from Senator Sanger about his wife? Would that?
I'm giving you all examples of what's going on in this community and in our suburbs. Like, we need to stay ahead of it, if in the interest of being transparent, if that's what we're trying to do.
But nothing about us saying that there'd be nepotism and you cannot be appointed if your spouse or partner is on the city council person, a sitting city council person.
I missed the question.
So what I hear you requesting is that we add paid positions or appointed roles of spouses or partners of sitting city council people.
Or add the appointment. So it's all, the relative definition is already in there. The paid piece is already in there. Nepotism is already in there. So what I'm wondering is if you all would like to think about considering adding in the appointment of commissioners.
Dr. Martinez?
Watson for bringing this to our attention and for showing up. I'm interested in, I know it's a policy issue that you're raising, but I'm interested in knowing if this is on the part of this person, this is an act of commission or an act of omission, and what remedies have been taken to ensure that she doesn't do it again, or is this a pattern that we're seeing?
So, that goes to the nuances. City
Yeah.
manager decided to email a group of us and tell them how I felt about the situation. And it becomes a CYA thing where they're worried about their jobs. City manager reports to council. And so, and staff liaison reports to city manager, who reports to council. So to me, they responded the way they did, which is out of character. I've never seen an open meeting be able to be canceled by a commissioner anytime in my life. So I'm like, what's the differences in this situation?
Okay,
Can I follow up?
Yes.
Sure. So is this something that goes on, with this person? What kind of, communications were had with this person? I mean, there's a chair of the commission, right? And she apparently is not the chair of the commission, or is she?
There's not. We have a chair and we have a vice chair.
Thank you very much.
Thank you.
It sounds like we could add something about appointments. It is pretty broad about different family members, council members or the city manager. I don't see how you could do something like addressing the same situation. He's got a free speech.
Oh, no, I'm just kidding. I'm just talking about the vibe of our suburbs right now and it's concerning.
I totally understand you. I appreciate you coming here too. I want to punch here. You hear from somebody. My other question for anybody, maybe for Diane or Mark too, is how common is it that relatives that fit this definition 7.12 of a council member, the city manager are on commissions? Have there been other instances in the past where that is a problem?
there have been. I know of cases where there's been someone on a commission and then the person is elected to council. So we can have that discussion. It's scheduled, chapter 7 is scheduled for November 21st. So your comments that'll be a good discussion that we have when we go through chapter 7 at that meeting. And if you need any more information, but I know that hasn't. Oh, Mark, you want to go stand up? Okay, and you said sorry.
Just one more question, please. I wonder, this is an interesting discussion, and potentially we could expand it 7.12 as opposed to adding another section to it.
Sure. Next meeting, our next meeting. Councilmember, did you have any other city that went on?
Yeah, I'll take 3 more minutes because the mall closes at 8 or it closes at 9. I'm not really sure and I need to shop. I just wanted to give you one more example. Our interim police chief invited and handpicked 2 people on East Lansing Independent Police Oversight Commission to be a part of some type of interview panel. And this person was one of 2. The second person that was invited thought it was a little funky and so back to chair and co-chair. But again, it's just like, what is the thought process when we don't have those clear lines and when we unintentionally appoint someone who is we're really following that. And so the next thing, which is a smaller thing, is the standing commissions piece in part 4.8. It's like 4.8D. I just don't know what that means, and I'm on city council. So this, and a lot of the wording is, there's a lot of words, and then you just see that one sentence. And so I'm just saying, like, I want to, abide by the charter and stuff like that. But I don't know what that means. So the lay people might just read that.
That was 4G.
Yeah, 4.8 something D.
I can answer that right away.
Okay, but yeah, we should.
A standing committee would be like the always, on the planning commission, when you're on the planning commission, they had maybe a northern tier subcommittee. And that was a standing committee, you get a report, or you had the CDGB committee member, that would be a standing report, because that's a committee that's sort of associated with planning. You can't do anything like that. That's a standing committee, that it has to have a beginning and an end and purpose for it to be a committee from council. So you can't just create a committee, appoint people, and there's no end in it. goes on and on. It has to have a purpose. So an example would be the park naming committee. That's not a standing committee. It's one that's appointed just for that. Or, I'm trying to think of another committee.
Me?
Yes, our committee. There's a beginning and end.
That's good. I think it should be expanded upon in the charter. If someone's reading it and trying to make sense and wondering, am I doing something wrong or not? I think the lay people should, have it defined. And,
That's a
I-
discussion.
yeah.
That's right.
I gather with my, council, groups, my commissions that I liaison for, and we meet virtually. So I've passed the word on to them as well, that if there's something that they want to bring to you all's attention, there's multiple ways, to bring it to your attention. But if there's anything else I can do to, support you guys or get community input, I'm just here and again, just appreciation. So, you're all doing, sir.
Okay, thank you.
Yeah, thanks a lot. Have a good day, everybody.
Okay, we don't have any more public comment here. So we're going to move on to the charter review, the committee charter review communication from us back and forth. I don't know that that's charter review communication. That means us. And so the first thing I'm going to say is we don't have Mr. Bellman and we're going to have Mr. Chubb because they were going to be at the Housing Commission. But he's coming in and out, and I'll let you introduce Ann.
Yeah, for sure. Yes. So actually, Mark and I both have an issue before the Housing Commission. So when we do leave, we're just headed down there. We're waiting for a text to tell us when it gets up on that agenda, and we'll be right back. This is my partner, Ann. She'll fill in for me, and we'll stick around for the rest of the meeting. Presumably, I'll get back. Ann's been with our firm a couple of years now. Prior to that, she served 15 years as a Wayne County prosecutor and subsequently an Oakland County prosecutor. And so she works in the municipal group, works on prosecutions as well as civil work. She did when she did forfeitures.
The other thing, this came up to me, whether we should reschedule this meeting because our attorney and our city manager wasn't going to be here. And I made the unilateral decision to say, no, there's a commitment from you, there's a schedule from you, we'll just go ahead and get to a point where we have a question legally or citywide, we're going to just put it on that sideboard and we'll keep moving on. But I believe you all made a commitment. I don't want to reschedule it another week and then that's not working for some of you. I think we're going to commit. And if that's the way everyone feels, I'll keep doing that if something comes up. And I'm saying that. So right out. So okay, and anybody else have any comments about it as we're going on? Okay. We're on to new business. Also, I'm just going to say, maybe we should have a discussion whether we should do old business first and then new business so that we can go back and forth with what we've done so far and make sure we can close the loop on that. Does that make sense?
It does.
And I would have moved the agenda around there, but I just thought, I don't know what his plan was exactly. So everyone's okay. We move to old business first and go over what which other was. So we'll go through the first one that's listed on here is section 3.4. And
Yeah, so and just remember everyone, I'm not trying to inject my thoughts or policy in this in any way. I took as good of notes as I could and tried to recreate it within these documents. If it's inaccurate in any way, according to your recollection, just that should be the conversation and we can fix those. I put them in resolution format so that if this is committee wanted, then you can pass these, which we will collect them all and then collectively send them to the city council at the end of your review of the charter. And so 3.4 is regarding vacancies in office. And so there were a couple minor changes as it relates to 3.4D. There was, and I'm going to paraphrase everyone again, not trying to inject my own opinions, but there was some thought that this was an arbitrary or lead to an arbitrary result where we had misconduct in office includes but is not necessarily limited to, and the request was to remove that, but it's not necessarily limited to. And now I'm looking at this, I think we should remove which as well, just so that that flows better.
I would think add a comma before or after office as opposed to moving which I think would be better than my mind.
Oh, sure, Ed.
Put a colon after it, please.
I think that probably makes sense.
So, Mr. Hanks put an email out to everybody. I don't know if everyone's read it, but perhaps you should explain your rationale and your discussion on this. And I was gonna say, I hope that this happened to all of you, that you went home after last time, the first time we got the charter, and then you started thinking about what we sort of decided on. And that's a good way for us to come back and revisit and not vote at that meeting, so we see what we have. And we have to have the discussion we do. So, go ahead.
Okay, so, well, first, I sent an email, one of the disclaimer here, I don't feel a good impression on, as I haven't been for scoundrels on this, but, I think some of the stuff is exclusionary, that the trend should be towards including people in the franchise of democracy. You know, some of these things could be very serious offenses people commit, some of them could be petty. I just, big picture, don't like someone being removed from office unless it's by the voters, unless they're incapable of conducting business, like they're in prison or they're dead. They missed a lot of meetings, like we discussed before, and their attendance policy is good in that regard. If we were to go with something like the resolution proposed, I mean, again, conviction for felony in office, I think Ruben responded to this earlier. Again, this could be a felony in another state. So this could be a felony for something that is legal in the state of Michigan. So I just think that a lot of this should be either further defined or removed, even though these are probably highly unlikely circumstances to occur. This is our opportunity to tighten things up and to make it better. Lots happened during the past week. There's presidential election behavior I witnessed of a city council member who was talked about earlier on election day. I think the misconduct in office is too vague. And originally I thought we were doing the right thing by moving, but it's not necessarily limited. But you almost have to have that in there, or we have to expand the definition here, because this conduct in office is in 3.13. So if you don't include that part in 3.40, then what is misconduct in office in 3.13? Meaningless. We have pecuniary interest because it says misconduct in office, but we remove not limited to, and it's defined here as a certain thing. Right? What does it mean in the other sections? It also pops up in these two other sections, 4.9. Failure on the part of any officer of the city, so this isn't just elected. 3.4 applies to elected officers. Right, so this is another one. I mean, I'm jumping around, but just trying to get all this stuff congruent. So there's a single definition. Comes called misconduct in office. It's clear who it applies to, it's clear what it is.
Well, then there's conduct and misconduct of both in there. So that's.
Okay. So either way, there's provision in 4.9 about misconduct in office, and that applies to non-elected officers, which me raise the question, what happens to them if there's misconduct in office? And there's nothing in the other officer sections that we haven't gotten to yet, like the city attorney, the CFO, anybody else who's city manager. That stuff dealt with in contracts, employment agreements. And then in misconduct in office also pops up in biggest point. Find right here off that, but it's in the section about council members acting orderly. Yeah, it is orderly, right? So I should have my notes in front of me. But anyway, that raised some questions for me too, because that's not. Yeah, misconduct in office, what does that mean? What is disorderly? It sounds like other council members can say you're disorderly at a meeting. Then you're disqualified from office. Well, again, maybe I'm thinking hypothetically, but we had factions on council and things got repeated one night in discussion. Majority faction can say, we don't like so-and-so, we don't like Pam, we're gonna choose disorderly, right? You're disqualified from office. So some of this stuff is like criminal and then some of it's not. I just think it's not. Right. And again, I don't like voters not being the ones to. So summarize here, so I'm not going on and on. I think the felony thing needs to either be further defined, like the felony in the state of Michigan. If we're going to keep it, it should definitely be included in the resolution. So we're not just talking about 3.4D. And then in the 3.4D needs to have a comprehensive definition of what misconduct in office means. So it includes anywhere it's cited in the charter. It's not limited, so it can't be confused with this. And it's just my understanding, like, I left the other day thinking about students. So if anything's happened, the person is disqualified from office. Our second piece of that was we're going to have a special election. If that happens, that's understanding. So you are
Specific,
but you can have a special election.
I had to especially for kicking them off, or off for those other reasons. So like,
Person can run. So, and then there's just a couple other quick things, but like misconduct in office, I think you could interpret that to be you're in office. But like section 3 says, committed well in office. These other two don't say that, so I mean, I'm assuming they would probably should all say, like, so what is the principal telling everybody? It's exclusio uno est story, like, you know what I'm getting at?
Yeah.
So if you include a phrase in one sense, but you don't include the other, it's deemed like intentionally that you didn't put it in there.
oh, so it's not assumed to mean the same thing, it's actually.
Seems like we would know what we're doing if we didn't include it in one part, we include it in another. we don't.
So does it make sense, that we take this section, since there seems to be more discussion, and Jonathan will be the next person to talk, but does it make sense when we have something like this, where it's cited someplace else, that we put that aside and start adding all the places that it is, because we're uncomfortable with it, rather than trying to decide now? Let's wait to see where else in the charter we're using it, so that we're consistent when we come back to the first definition.
I tried to look and I didn't see it elsewhere, but there's at least those other 3 references besides this section. So
That's what.
Yeah,
it's just either like that's got to be removed. So those things,
And it would be great, I think, interrupt, but it would be great if there was consistency as it's mentioned in each section. Unless we're going to have a section that covers everything.
Like the definition.
And have a definition, but in each we should be as expansive as, equally for each one, because I think you're saying it's unclear. It's more clear in some sections than others.
yeah. And just to make this point again too, what about the non-elected officers? If they can commit misconduct in office, what happens?
We haven't this.
They don't have special election.
This charter is for officers of the city, and it's 5 people. That's all it is. Officers and 3.1, it says, the officers of the city shall just be those 5 people.
True.
We're not talking about staff at all. We're not talking about anybody else. It's just those 5 people.
That's true, but also 4.9 though will say, any officer, so that's not just the council officers.
Well, then we might have to take that word and
Just
change
not-
that.
What I'm saying is, if you saw that, then you say, well, where else in this conduct not mentioned, you go back and just tell them the way we define it, right?
So I think that I think that it's fine as written by Tony. I guess I have 3 points in response to what Jeff was saying. The concern about misconduct in office and its definition, I think is cleared up by 3.4D3, which says that conviction of any act committed while in office, which constitutes misconduct in office under other provisions of this charter. So that's wide sweeping. It takes into account all other instances throughout the charter where something is defined as misconduct in office. I understand your point about 4.9 specifically. For non-city council members, 4.9 says if you do this, you commit a misdemeanor, which means that the city attorney could criminally charge you. That's how it's dealt with for non-council members. So I think that makes that point pretty clearly.
Yeah, I don't want to interrupt you, but that says an employee of the city, so that would have to mean every other officer is employee of the city for it to be misdemeanor, which I assume like the city manager is an employee. The attorney is not an employee. It's a contractor. So, and then Jonathan, your 3.4D argument would require a conviction. Not going to be conviction for someone having a pecuniary interest or acting disorderly at a council meeting, unless that's like a disorderly conduct crime.
So I mean, we could change the word conviction there, we can make it a finding, but I think that would sweep it up in a way that's productive as opposed, and we should be certainly be keeping an eye on what, as we go through the charter, as to what is defined as misconduct in office, because that's obviously very important under this provision. I just want to make two other points in response to the email you sent earlier. The first being about conviction of felony while in office. I take your concern about what might be considered felonious in other states, and especially given the events of a couple days ago, I particularly take that concern. But when we're creating policy and when we're crafting what we think the best policy is for our city, I think we should be worried about the 99.9% of cases as opposed to the 0.1% of cases. I think we created, in 99.9% of cases, if someone's convicted of a felony while in office, it's because they assaulted somebody. It's because they committed a financial crime. It's because they've done something worse than assaulting somebody. And I think that it would be highly embarrassing for our city if we had a council member convicted of something sitting in prison and the rest of and council was halted. It went down to 4 members for a period of 2 months. And because we had to wait for them to miss 4 consecutive regular meetings while sitting in prison. I mean, I just think that's, so I take your concern about what could be considered a felony in other parts of the country. But I think that we have to be focused on what policy is going to make sense the vast majority of the time, instead of relying on worst case scenarios of what might happen elsewhere. And then my last point is about your view that this is anti-democratic. I disagree with that a lot. What we're doing here is we're asking the voters of the city whether they think it's a good idea to automatically remove a member of council when that member of council behaves badly. That is democracy. We're asking the voters of the city if something should be done. That's what democracy is. We're not walking out of this room with stone tablets or anything like that, saying these are what the rules are. 30 years ago, the voters decided it was a good idea to put this misconduct in office provision in, saying that if someone commits a misdemeanor punishable by 6 months or more, if someone violates PPO, if someone commits a felony, that they should be automatically removed from office. I think we should take the wisdom of those voters. And now what we would be doing here if we pass this resolution would be putting it forth to the voters again to say, do you think this is a good idea too? If they decide no, then the answer is no. That's democracy. If they decide yes, then the answer is yes. And I disagree wholeheartedly that this provision would be anti-democratic. I think it's the exact opposite. It's worth automatically removing somebody from office, and we go with the will of the voters at that point. But I think that these are good guideposts and something that we should, considering the gap, especially with assault and battery and domestic violence, that's certainly a gap that we have in this misconduct definition right now. But I think it's something worth putting to the voters to decide if they think that's bad, that that's something that should automatically be through.
What I'm hearing too is there's the felony and criminal issues, and then there's being too rambunctious at a meeting or kind of undefined non-criminal acts that you put in. Those to me, that totally separate issue.
And I think that's absolutely, those are two totally separate issues, and I think that we should, now that this issue has been raised, we should really keep an eye on what is defined as misconduct in office as we review the rest of the charter, because we should maybe act some of those as we go.
I think that, yeah.
Yeah, I think I would feel better, maybe I guess it's kind of sense everybody else is, but I think there should be a special election here. For any reasons I can. At
Okay,
least you have the opportunity.
we'll get to that one because that's not.
It just ties into everything. That's like, I can see myself supporting some of this from back.
Lynn wanted to say.
Yeah, the only thing that I would kind of, I wholeheartedly agree with Jonathan Foreman about this. About his perspective on this being anti-democratic, because I do think these are not things that we're adopting. These are recommendations we're making to city council, and if council adopts them, then they do go to the electorate, and the citizens of this community decide whether these recommendations go forward or not. And I have two other things. One is this conviction of a felony while in the office. While Mr. Hanks suggests that it be limited to Michigan, I'm with Mr. Foreman on this. I think that the problem is that it's because we're so close to borders. If for some reason somebody goes back to crosses the border to Indiana and commits a major felony, like murders his or her spouse, because for whatever reason, the fact that that murder takes place in Indiana should not mean that we have somebody who's able then to sit on city council. We just don't want that partnership of that. So I mean, conviction of a felony, it should be a national kind of determination. I'm sympathetic. I heard or I read what Mr. Hank had said in his memo, but I'm not persuaded. I think that's the 1/10 of 1% of what we're likely to encounter. And the only other thing I have is, of course, our word is a bit of wordsmithing. I would, reading this vacancies in office on page 27, any elective city office shall become vacant upon the occurrence of one or more of the following events before the expiration of the term of such office, skipping down to misconduct in office, comma, including semicolon, is how that to me reads more smoothly. So it's just tweaking, a bit of the wording.
What section?
Section 3.4D.
Yes.
It's just that bit on that little bit there.
All right, so just that word changing the punctuation, is there any disagreement on that? Because again, I captured that. Before. How about, we've had this conversation, we want to just set that aside until we get to the floor and make sure before we take a vote on how we want to do this one in particular, and just so that we make sure that they're going to match. However, we decide that when we get to the chapter 4. Is that all right?
That's why
All right. So, okay. So the next one I think is an easier one, but then I read your memo, so you might want to talk about that. 2.2 is the next one that we're going to discuss.
We discussed last time on 2.2 adding economic status as well. And I think that got missed in the drafting of the resolution. That was still something that the committee wanted to propose.
Yeah, I came away thinking we were gonna have this expansive list. That was like, everything protected under, federal law, state law, but also like federal law could change.
Yeah,
We have the ability to protect people here however we want, because as long as we're not violating state law. So I thought we were gonna do something, I just expected to discuss whether we're gonna have aspirational type things like some of the other state charters have.
yeah, I really appreciated Jeff including that. We talked about possible preamble and including what Flint has in their charter. And that, because that initially I brought this up because it seemed so limited. It seemed, are we only protecting marital or family status? And I'd expected to see the usual suspects of protected classes articulated. And if we articulated those in a preamble, we wouldn't have to articulate them here. But I find the wording strange to have any class protected by federal, state, local, and marital and family status. Do you need that? Is that not protected in any federal or state?
It's not.
No.
It's not.
Oh, interesting.
And we also have students, which isn't listed there because we do have that in our human relations, that students are not discriminated
That
against the student status.
Where do we have it?
It's in the city ordinance, right? So that's, I don't, you have Mark stepped up too. I thought that's what, I was hoping Tony would copy from the city ordinance all categories.
Oh, so you thought you said, yeah, I wanted that.
Yeah, then we would say, let's add economic or whatever else.
Yeah. And I wasn't sure if that would go here or in a preamble. We have a declaration of rights. And then include marital status, socioeconomic situation, and family status, and
Well, go ahead.
Mike, I'm going back to one of the comments that Jeffrey made earlier, and that's it, you know, when you start listing specifics, then are those the only bases that we're going to bar discrimination on? So, and then if we start listing all these specifics and somebody comes in and says, oh, but I can discriminate on this because it's not included in this list. Is it possible, and not just tossing this out here, I missed the last discussion, but to list this, the city and its officers shall not in the exercise of any power granted to or possessed by the city discriminate against any person, period. We don't discriminate, just period.
I think the problem with that is discriminate is a very broad term itself. So like when you make a decision on something that you potentially discriminate, like licensing decision even, you're like, no, this person's driving license or doesn't. That's why they usually have race, sex.
I will, then you have to, where's the listing going to end? And are we, boxing ourselves in? Because I'm just concerned that somebody's going to find some reason to say, or if somebody wants to discriminate, well, I'm sorry, but it's not in this list because, we can think of, I don't know, some unmarried, bisexual, I don't know, people of color from this particular, it's not listed in
I
this.
think all that's covered in the city's ordinance. That's why we should have I think we should at least have the list to explore it. Then you can see if it's comprehensive or not. Have to pay if we're missing something that we're somehow gonna open discrimination against somebody.
I might add that having that ordinance world is a extensive world, and to look for this seems to me that it's preamble kind of statement, a declaration. I think something like that belongs in the charter. Like, yes, we have ordinances, so many detailed ordinances. This is more of a declaration, right?
I would wonder, can't we do both? Can't we have it in the preamble and then have it where it really needs to be in an area like this? And I agree with you, Lynn, that, on its face, if we just said discriminate against the person, that would be enough. But someone may ask, discriminate about what? And so, if we include the socioeconomic part of it, I think that really does help. And it does cover, race, culture.
That charter
So
does a nice job.
if I may, so the city code, it's not just an ordinance. Against discrimination and prejudice based on religion, race, color, national origin, age, height, weight, disability, sex, marital status, sexual orientation, gender identity or expression, student status, or the use of adaptive devices or aids. It's pretty broad. I mean, there may be some other things.
Like a native Michigander, maybe they decide to choose to discriminate against me because I was born and raised in Michigan.
As long as
That's what I was missing from that.
Yes, as long as
That's
it's-
right.
I'm sure not from Ohio.
I mean, it's generally unconstitutional to discriminate against somebody based on residence as well. We had that discussion last time too. You can't even do that for someone who just moves here and wants to run for office, that sort of thing.
Yeah.
I I think when we say federal, state, or local law, that's very expansive, as of right now, because federal law, I mean, the problem with creating a list is that you're never gonna get it,
But we already agreed.
if that's everything.
No.
Does that include the next thing?
But,
right?
of course, it can't include the next thing, but it is a list that the city has chosen to create. And so why not place it here as well?
Because it's, and my answer is it's much easier to change an ordinance than it is to change.
So you're saying the thing we need to add that we didn't get covered could be changed in this ordinance, but then since we're gonna be meeting more regularly, like every 10 years, we would revise this charter to align with the ordinance as it changes. You know, I hear you.
You can put the period after person, like eliminate, I mean, why have marital family status?
Yeah, that's-
There's some word to leave that in there. So either add them all or go with the categories or just discriminate against the person. Options.
So this
Does it go, sorry.
This is basically a matter of wordsmithing. So you can just put a comma after person and say to include, and then you can put your whole list of categories because it doesn't really say, doesn't really mean that it's only those things. It says to include, and you can, it says, okay, there you have it. It includes these things, but doesn't exclude others either.
Okay, can we do like 3.4 and say includes, but it's not limited to?
Discriminate against or not.
So I'm hearing Dr. Martinez that if we did that, if any person, and then you listed those out as you,
Yeah.
That's
It's not to include.
to include, then if we have to look at the code, the ordinance that refers to non-discrimination, and you can have those things put in there. Well, are you concerned about the federal and state versus what we have in our ordinance?
So
What would we be missing?
could you read the ordinance again?
Sure. I'll paraphrase. No discrimination or prejudice based on religion, race, color, national origin, age, height, weight, disability, sex, marital status, sexual orientation, gender identity or expression, student status, or the use of adaptive devices or aids.
That's where this, yeah, I mean, I guess someone has a disability but doesn't use an adaptive aid, that doesn't cover them.
It says disability. And
Did I say disability? I said again, okay.
listen, man.
I guess. Yeah, I mean, so I mean, I guess my concern with what Lynn was saying, that you can't discriminate against any person, period, is that, you know, when the city is getting out contracts, by definition, you're gonna give someone a contract who's better at the thing that they're doing, right? And if then that gives rise to a lawsuit saying you discriminated against me because I'm bad at my job, or I'm bad at what I. So that would be my concern there. But I don't know, I feel like, you know, federal law is really expansive. It includes race, gender, now includes sexual orientation as well. It includes gender identity.
I don't think it does, and I think that.
But state law does, right?
State law does.
Yeah, Supreme Court did that a couple years ago. State Supreme Court, Elliott Larson covers all of these things as well as the state civil rights act. And so the only thing that really, and I think that protected by federal, state, or local law would also include the ADA. So disability would be included there as well. The only thing, and so that's why when we were here last time, they said the only thing that stood out to me as missing was economic status, which is why I want that.
And students,
And student status, yes.
that was very specific to our
Yeah.
community.
So food for thought, a future council could restrict what's in an ordinance, could remove some ordinance. We put a protection in the charter, it's gonna be respected until city council puts it to voters again, and we voted on change. So we set standard. It doesn't mean that additional categories can't be added to an ordinance later on.
Or added to the charter.
Or added to the charter.
Basically.
Yeah.
So do you want to use federal and state and our code, and put what's in our ordinance right now, include that in here as, that's like the whole shebang there, and that is protecting you from, anything that's taken out of the federal and states. Well, we've already got listed as things that are important with us.
I think that's important, reading about the home rule and making sure that you are independent of state and federal laws within legal limits, but that you can do more than the state maybe wants to do.
You gotta look at it as sort of like, we're guarding against really bad futuristic tells. So imagine your nightmare.
State laws.
Yeah, but
That's state laws.
so this is our chance to sort of say like, this is our little roadblock to bad government in the future.
I think what's being proposed is more detailed than what the state and federal laws say. That's the whole point.
We're allowed to do that. That's our right. So
Can we do it with like local laws, codes and ordinances?
I don't think,
Instead of going through the laundry list of
yeah, but
everything?
ordinances should come from this, I think.
if you say that, then again, the ordinance can change
Right.
negatively in the future, for example. But also change policy. But if they change policy, they'll be protected. If they change it negatively.
Makes the charter subservient to order.
Right.
I like what Diane proposed for that, is federal and state laundry list we have, and if you add economic stat or someone that wants to add something else, let's come back to that next time and say, here's what we should add, or if you have to pull them out, and just add it now, I'm just saying, I like to see this stuff on paper and think about it.
Yeah.
too.
I think that did you.
I agree.
And if you don't include, and if you don't list any of the things that are included in state and federal, just include the ones that are specific to this place. That way you don't have a whole lot.
And I just agree with you with how comprehensive you're making it, because, really think about it, we've got a new review coming in, federally, which could eventually filter out into the state and
Especially as we talk about the gender identity issues, facing out to
yes.
individuals.
That's Dr. Martinez. I think that streamlining it would be good. I'm just concerned that a bad actor who doesn't want this to pass could then turn around and say, why would we pass this ordinance? It doesn't even include race. If we're thinking about what a campaign would look like against this passing, where, we're all on the same page, but we don't get to go vote to the 15 or 20,000 people who are going to potentially be voting on this directly. So I think we should be.
So wait, are you saying we're tricking the voters into?
No, I'm saying we should not streamline it. I'm saying we should say everything we mean to say, if that's the path.
Oh, okay, I thought you meant.
If that's the path that we're deciding to go down as a committee, we should say everything we need to say and not fall back on federal and state law.
Right, because no one knows what that is.
Okay, so we include that, Tony's gonna try to draft that, you've got that hand.
So, yeah, so we're gonna say of any person, comma, and then we're gonna go to federal, state, local law, including, then we'll include the list from the ordinance. Did we want to have marital and family status still? Yes. And then what about, there was a discussion of economic status. Is that in there? Okay.
You don't want to revise the ordinance.
Marital status isn't.
Is it? Okay. Family?
Family status.
Okay.
That should, I think that should be.
So since Asia's here and she does the agenda, I'm just gonna say, so far, we want 3.4 and 2.2 also on our old business next time. With the revised. I'll go to 3.6. The next. The next one. So I have some business. This is one I just want to start off by saying, I went home and thought about this. I remember we had a special election one time. And I remember everyone was sort of grousing about the special election. And so I asked the city clerk about this. And there's rules now. So first of all, a city cannot call a special election, period. That's not allowed, according to the clerk. There are certain dates in the law that can be set for special elections: May, August, November. So those are the 3 times for that. And we don't have the ability to simply pick a date. Only the legislature can do that. So we can't do that. So then I said, I remember we had a special election. It was a county commissioner who had moved out of the district, so he wasn't living in the district, and we had to have a special election. That was county, and the schools can also call for a special election. But The city cannot. That's something that the legislature did not allow. A school election, I'm just gonna give you lots of information. A school election cost, an extra election costs 50, last school election costs $56,000 to call an election. Again, is that something to be considered? And that doesn't include the overtime on the workers and any extra costs. Just the election itself is gonna cost that. It takes 3 months to set up a special election. And the state statute is the one that says we can't do that. So when we're talking about filling the vacancies, we have currently right now 30 days to fill a vacancy. And the council members do that. So it seems like we don't have the option for a special election until the next election that comes up that's scheduled, then we can replace a person that way. But then we'd have to take out the 30 days. It could be empty for a long time. And because we have 5 council members, just what you said, Jonathan, that it starts to seem like it isn't fair to the rest of the council members, and it isn't fair to the community to limit the people that can make these decisions. And as you see later on when we talk about this, a quorum is 3, but you can't pass an ordinance with less than 3 people voting for it. So if there's only 3 people, that's in our thing. They all have to vote for it, or the ordinance goes down because don't have 3 votes at a meeting when there's only 3. So it seems like you wanted to maximize the time, minimize the time that you have a vacancy and maximize the number you have president. So my thing's on this. So do we want to revisit this?
Sounds like we have to.
Yeah. Yeah, we can't put this law.
Yeah, and I think that in speaking with Marie, like, I didn't think about the fact that a special election is defined in Michigan law. And I was thinking more of a more generalized term, special election, which would technically, as I understood what everyone was saying, be held at the next available general or regular election.
School board just
Right.
to fill this second.
Right, so you do typically your May, August, November. But that does, a special election theoretically is where we just unilaterally set a date and say our polls will be open November 15th to have this. We cannot do that. State law absolutely does make that admissible. I guess is, as you referenced, for example, if the timing was such that we were not going to be able to meet the May regular election time because it happened early in May or early the following month, then we'd be waiting till August. And so that is a substantial period.
Well, everything's up 3.4 on
We can't do it for the zone.
but
We wouldn't be able to do it if the guy was, the member was.
yeah, if I can, do you mind if I say something about this? The special election in particular. I haven't ever been on council when we've appointed somebody to take the place of a councilman, but I've caused that twice. So I'll just note that the council has followed probably an unwritten policy to advertise it to the community immediately, invite people to apply to be appointed to city council, and do public interviews on television of anybody who applies, so that the community itself and the council can feel comfortable that people have been viewed and given an opportunity to make their case to be on council. I think that the appointments that I recall occurring on this have been solid appointments by the council. Nobody likes to weaken the council. They're always looking for people who will be strong on the council. So the thing that I think is absent here is this process that the council has developed to appoint people. Because technically, they have to appoint within 30 days. They could get together at lunchtime the next day and appoint somebody to it without ever involving the community. So if you're thinking about adding something to this, it may be to make sure there's a public process that relates to this appointment.
Well, there's one time when that didn't happen. And that was when there was that short period of time when Stevens resigned and they asked for volunteers. And then Shanna, who had been on the previous council, she was just appointed because the period of time was so short. They didn't do public interviews. They just took her.
No, we had an election coming up and there were already candidates for that position. That's why that happened. And I think that's happened previously too. Like right at
Right,
the
with
end
other
of
student
the term,
that
they appointed somebody temporary.
And we can say less than 4 months to serve.
Yeah, that's what I was going to reference. The last vacancy that we had was when Judge Babcock was elected, and we did follow the exact process that Mark was discussing. But in order to do that and be able to fit it in the 30 days, we had to work with her to strategically submit her resignation letter so that we already had the posting out there. We already had meetings scheduled that where we would hold interviews, because that was a really tight time frame to do a comprehensive evaluation of all of the interested applicants.
So would it be simply to say, we know that you have to have it in August. There's a certain date, certain, you have to put your name in to be elected. And if it was after that time, then the council could appoint. But it seems like you're really muddling up the charter.
Yeah. I wondered, do we need to put that in the charter, since you were mentioning that you have a process that you've been following for some time?
I don't think you have to be so detailed as to say that, they have to, within 24 hours, notify the public that there's an opening and that, they can put their applications in. But I think if you made reference to some language that said something like a public process involving applications for the position is enough, because you've got 30 days. So council isn't going to drag their feet on this. They've got to get it going anyway, as long as we have that time frame.
So maybe what you're saying is that you should just say a vacancy will be filled after a public notice and invitation for anyone to apply.
To apply. Yeah. I think
And then
that's-
they can look at what date it is, whether they just want to, just for 1 month, we might do something different than if it was for 3 years. So can you do that?
That's going to strike out the additional language we had proposed in 30 days.
Was 30 days enough? Do you want to go to 45? Or do you think 30
I think 30 days today is actually more reasonable than when this was ever enacted, because we have more opportunity to interact with the public, I think, than we've ever had before. Especially
Like
the city council.
electronically.
Yeah, so, back in the day, if it's 30 days, it's like, okay, how do we get the word out, basically. So I think now 30 days actually works as opposed to, longer periods.
All right, so we're gonna put that one aside too, come back to that. So that'll be,
let's just, what was it though that you wanted to, do you want to take the 30 days out or you're leaving it in?
No, I would.
Okay, and so what was the portion that, or do you just want to readdress it at a later date?
no. When a vacancy occurs, the public will be notified and invited to submit their application if interested, something like that.
Public notice application and hearing.
Yes, that's good, because that's going to have to be at a hearing anyway, but emphasizing that as being something that is public comment.
And so then, and one other thing that I just point out, because this gets into the new business that we have tonight, is so filling of vacancies, it references appoint a person who possesses the qualifications required of council members. And that goes into section 4.2, judge of qualification of members. Council shall be the judge of the eligibility and qualifications of its own members, subject only to review by the courts, which I think is kind of a unique charter provision. Yes. With a little bit of vagueness in it, but I just wanted to make sure.
It's a charter provision that sort of reflects the state constitution. The legislature is the
judge or the qualification to the body of our members, and technically, a person can get elected, sworn in, and the rest of the legislature, the majority of the legislature could say, you're out of here.
But
So
doesn't
it isn't, but it's reviewable by a court, which then has to look at the reasons and rationale that was proposed. So I think there's protections there.
Yeah, because when we look at like section 3.4 and the sections and all the things that we have all these qualifications or removal sections that are enumerated, and we wanted to tighten those up, whereas this is an arbitrary or not.
arbitrary, it feels kind of arbitrary.
I mean, so where this is a kind of a catch-all, and if they don't like you, then
Has this ever happened? This knowledge?
I'm not aware of it ever
I don't see
ever
it.
happened. In fact, I think there'd be requalifications against the other council members if they just one day said, hey, we're getting rid of this guy, and kind of argumentative. So,
Should we be something to add to this, that essentially there's some, this, like, this conduct has to be a ground for qualifications, or is it? How it is?
well, the question I would have on this particular provision that we're talking about is, do we really need this? Given that we have this provision that talks about misconduct in office, conviction of a felony, conviction of a misdemeanor of more than 6 months, and the other parts of that.
And then the voters.
Yeah, and then why do we need this?
What are you saying, strike?
And if you're so bad that there's a recall provision, then the public is taking
There's
care of it.
rules about it.
So I personally don't think we need this. I think it was just put in there because it's typical of legislative bodies.
So you're saying strike 4.2?
Support that too.
That.
So we're skipping ahead.
But don't you have to, in the application process, let the public know what they're looking for?
As long as you're saying those are the qualifications of the judgment of the intelligent people that council chooses. Maybe that's
Or
what.
just say something, consistent with visions of the charter.
Are the qualifications, you're 18 years old, is that it?
Yeah, it's not a criminal.
yeah, not a felon, right?
Only, no, it's not a criminal law, you're not.
And the voters like you,
Well, yeah, so like the qualifications, aren't the voters really the arbiter of the qualifications for the members of the council if they vote for that somebody? That's what it seems to me, that voters.
My read of what 4.2 means is that that the operation, because we talked before about what operation of law means and how it's vague. My view of what 4.2 means is that council gets to determine if someone has committed a certain act. Maybe I'm totally wrong on that, but that's my interpretation. And then it's subject only to review by the courts because someone wants to sue and say, no, actually, you're wrong about your interpretation of this. That means that a judge could, it does allow a judge to look at it, which I think is important to add. It kind of clears up the operation of law issues that we were addressing before. That, if someone says, if someone is convicted of a felony.
Right, or
And counsel says, we don't think you've been convicted of a felony. And all counsel is in cahoots. 4.2 still allows someone to go to the courts and say that person should not be that person is not allowed to be on council.
I guess my interpretation of it was up to council to take actions when it is determined that someone through other charter does not have the felony or whatever. The council takes the actual action to remove them. Is that true? Like, does the council have to vote someone off?
I think this by operational law in the earlier part, so it doesn't require council action. Convicted of a felony,
You're off.
you're off immediately.
Who has to tell you?
Yeah, I was gonna say, who wouldn't, yes, it's a self. And that, it's an automatic disqualification. But somewhere along the line, somebody says, oh, no, I'm not going anywhere.
I think that's where our city attorney is our person that's going to say, no, you can't.
So that's.
But you could, if you wanted to keep that provision, you could narrow it to make reference back to the language there, so that if somebody did say, I'm just staying on, I guess got sort of a trustee in one of our townships is kind of saying that at this point in time, then the council would have the authority to say, you know, we find that you're committed a felony, that by virtue of whatever. It's important to remember that when a court reviews something like this, if Tony knows something else, defer to him, but I think this is an RJA 638. It's an administrative appeal to a court, and the determination by the court is just simply whether the council had the authority to make the decision. It's an administrative decision. So I think that doesn't really, that's not much of a court review. I'll be trying to say this. So I'm not sure what this means even now, but I think it would be a challenge by an individual member who said, well, I haven't committed a felony. I haven't committed a misdemeanor. I don't know why they kicked me off. You know, that's what our standard is. And we have this lawsuit determining the provisions of the charter. That isn't really what we want to have. So if you refer back so that the council as a backup could remove a member who actually was convicted and met all these other requirements, I think maybe that's the way you keep it. If you don't want to do that,
I think it's necessary to keep Mark, because I'm looking at the language of 3.4, and if the convictions of felonies, I think or the missing reasons and stuff, those are pretty self-executed. But we've got some judgment here with misconduct in office, including 4 criteria. And by saying it includes that, there may be other circumstances in which there may be a room for a disqualification that we're not sitting here, and we can't anticipate every circumstance that council would say, wait a minute, you've really overstepped, you cannot come in. And, you know, if it rises to the point where somebody throws a punch at somebody else or something, or a member, and nobody wants to prosecute that, you don't want to get it to that level, but clearly there's misconduct.
Well, that gets into the section I was mentioning about disorder. But if somebody punched on a council member, that, I think that's
That's a crime.
could be a crime. But you said it, well,
Get to punch it.
but it may not be prosecuted.
Right, it may not be prosecuted, somebody would scream out.
Or it's deemed not to be a crime.
It's the 4.2, then the council says, wait a minute, we're just not gonna abide, tolerate that kind of behavior here. So the council decides that you're being kind and listening to other people and agreeing, just disagree or whatnot, then you've got some sort of guidelines or something that gives the council a way to say 3 times or something in your hours. Or so we agree, we can't work with you, you've made it completely impossible.
Sorry.
I'm sorry, Jeff. I was also thinking that if they're looking, it gives some discretion then within the charter, that if you're having to select a new council member, then we've got, they can choose.
Every eligibility as you're actually eligible to hold office, like you're of age, assuming you have to be a US citizen.
You have to be a your voter.
Yeah, this is a resident.
Resident voter.
The qualification is something different. I'm not entirely sure what that means. You could be disqualified from office, we say like 3.4. But I'm wondering if first it was just scrap it, we're also, now there's, I'm just wondering, do you define qualification or?
It's part of the public action. So the council takes a public action. They're choosing to remove this person publicly because of felony conviction or whatever other reason. Everybody sees, the council's discussed it amongst themselves. It wasn't like just the city attorney. So I got a felony, he talked to him, never shows up again. You know what I mean? It makes it more of a public, if the council decides to remove someone. Is there not a point where if someone's going to be removed, the council has to vote to remove them? Even if it's.
The other thing is that we're looking at it, I can think of it as 30-day appointment as well. I mean,
Yes.
this also says when the council decides that person, that's council. they're on the council, so.
It accords them the discretion. That's what I was going to say. That's the other thing it gives them is
Has
discretion.
there ever been an action by council to remove another member that anybody is aware of?
I am completely unaware of any, not only am not aware of it happening, I'm not even aware of any conversation to remove a member ever. So,
I've only seen it in one community when a council member or a board member rather just quit showing up to meetings. And it was a 6 month window without any explanation whatsoever. Yeah, there was. So,
Got it covered.
yeah, and that's ours has it covered. And ours does it by, I think somebody else asked the question about council action. I think maybe that was you. You know, ours in 3.4 for vacancies, it says by operation of law and without. So it says the elective office shall become vacant by operation of law and without necessity of any action. And so for those, if there's a felony, if somebody gets convicted of a felony, they're out. No action needs to be taken by council. Some of these other things where we look at the qualifications that we're referencing in 4.2 or 4.3 there, 4.2, that's where you would have to have council action because it's more, they'd have to explain what the action is based upon and then take that action.
Should there be a reporting requirement 3.4, even though it's by operation of law? What if no one knows about?
Yeah, that's
And
what I'm.
then you have council members sticks around and it's technically voting on something they're not really important.
Or it's not apprised of why they were removed. It seems to me that should definitely be, public should be notified of why the removal.
I mean, to answer whether there should be a reporting, I guess the answer is maybe, if we're talking specifically about the conviction of a felony or conviction of another crime, you could say it would be a misdemeanor to fail to report it. That the most that the city could do is a 90-day misdemeanor. So we're not really putting, if someone is trying to get away with having a conviction of a felony, they've got bigger problems on their hands than not reporting it to city council. So I just tend to think it doesn't really accomplish much because there's just such little that could be accomplished. The punishment that could be imposed is so little compared to the underlying conduct.
So let's just take a current example. How would that fit into this? What would you see would happen with the current example in the other township? Where a person's arrested for using their phone to do an act that's illegal, but they're accused. They're not. How would you see that play out with our charter the way it is? And what do you think the actions could be done with that case?
While the case is pending, there could be a recall petition circulated, right? It's getting ahead of ourselves, but our system is set up that here, saying feel proven guilty. And I
Under
do,
4.2, could the council ask that? Could the council remove that person?
It's right, though. They almost have to have qualification by understanding.
I think conviction is,
Key.
is what is necessary under those circumstances. It's important to remember that the trustee was the only name on the ballot. So there was nobody running against it. It wasn't like there was this overwhelming public support for keeping him in office. It just happened that he was. So but I think a conviction, as we have in here, is absolutely a necessity for you should be even thinking about removal.
Someone could be innocent too.
Yeah.
So,
That's exactly.
That's pretty anti.
They can be falsely
What if
accused.
that person resigned? From their post. Pending the actions, legal actions, could they come?
No, once you resign, you resign.
That's it, okay.
That triggers the 30-day. You turn everything in, nobody can reconsider.
But
I had.
as I feel positive, you can run again, later after you resign. So
And win.
All right, so where we're at with this right now is we're going to kind of keep the misconduct off to the side before we approve it, so we make sure going through this, we make sure nothing else affects this or how other parts of the charter play off of this too.
so we just clarification, we should keep 3.4 on old business, but kind of like lying low on old business until basically the end.
Yes.
Okay. Sounds good.
Okay, Now, I really think this one's an easy one. 3.3 is the last one from our old business. And it's approval of the canvas of the election be added to that.
I move that we have to resolution.
Yes, you can. Okay, it's been moved by Mr. Foreman, supported by Mr. Wilkerson Johnson to approve the resolution on 3.3 terms of office. The change would be stated this way: the term of office of council members shall be 4 parentheses years. The terms of office of council members shall commence on and date from the Tuesday following approval of the canvass of that election. Any discussion on that? All in favor, say aye. Aye. All opposed, same sign. Yay. One out of 4, but I think you all agree when you went home and thought about some of the stuff you might go. So I think we'll see.
The ordinances that are becoming real.
Yeah, I think so too. All right, so we're gonna go to 4 now. Chapter 4. We'll first start with the city governing body. Does anyone have any concerns about that? We'll just move on to 4.2. I think our discussion was that we were going to leave that. 4.3. Now, this is sort of an interesting one because really what happens on council is that if council is going to do anything, the city manager's office pays for it. You don't pay for it and ask for reimbursement because you don't have the approval unless if you pay for it, you pay for it yourself.
So I guess this just creates protection that if an emergency pops up and you do have to pay something, as a council can then go back and say, yes, you should be refunded.
Okay.
Right.
If you were at a conference that was paid for by the city and your car broke down and you had this, right? Okay, guess we leave that in. Okay, organization of the council. I said I would do this each time we started a chapter, so let me just go back to that. When it was last, these were the things that were last done with the with chapter 4. They were they're all mixed up here in the order, but 4.3 they deleted the provisions that established a fixed amount for the salaries of council, and then what you have here is they went to the officers' compensation committee. Just an information piece. What was in there before was 1944 rates where council was paid $25 a meeting for each meeting he attended per year, not to exceed $1,200, and the mayor got an additional $300. So that was changed to go under the officers' compensation commission. The 4.9, which was publication of council proceedings, it said, and the meeting times were changed because it had Monday. They had the date in there, so they changed that. And then 4.4. That's where they changed it to Tuesday after the election. And then they also had one where the sergeant of arms was the person that was going to enforce everything, and they took that out. Especially when they were supposed to conduct themselves in an orderly manner, or be deemed guilty of misconduct, and the sergeant of arms would come and get them. So, and that was the police chief. So they took that out. You remember all this, Mark? And then 4.5 was amended so that they separately described the duties of the mayor and then the mayor pro tem. So it was all combined, and then they renumbered it. And then the restriction of 4.7 was the city charter was amended to make a contract with any person who's in default of the city to cure the default and eliminate restrictions or to sell property. And that was put on, and amended, and so they just restricted and took off the contracts. Council can't make contracts with people individually, in default of the city. So that would be like if you're hiring the electric company to do something, if they, haven't paid something that they're supposed to do, they're not allowed to use that vendor. But then in 2015 is when they changed that language of, it's $4 per capita according to the last preceding census. They put that dollar amount and then put the CPI there, because otherwise you were still using this old dollar amount and you never accounted for how property had appreciated. Yeah, thank you for that word. So that was the most recent one, was really having that in there so that they could sell it if it met that criteria. And the last thing was 4.9, which was investigations and requests for information. And they put that, and they said this amendment gives council members greater access to information from city officers. They use that word officer, and I think that probably that's something that we need to, if we talk about officers of the city, then that's a city council member. If we're going to talk about information from city staff and employees, access to information from city officers and employees regarding the conduct of their office, that they put that in there so they could get more information. So I don't know if you remember why that came in there, because that's a pretty, it's honest. I want to say that's a pretty.
I can tell you exactly why. There was a circumstance in, I think, 1993, relating to Tom Doherty, the city manager at the time, where council members were told you are not allowed to ask questions of any city staff. And it resulted in kind of a big deal with the council. And so when we decided to change the charter, we decided to take Tom, I think that led to Tom's departure. And when we revised the charter, we wanted to make sure that we ensured that we had the right to talk to the city staff anytime we wanted to ask a question, and make it clear that we don't have the right to order city staff to do anything. That's the city manager's responsibility, but that we can ask questions of anybody at any time regarding the operation of the city. So this was specifically put in there because of what happened with Doherty, but also to ensure that we were able to get information anytime we want.
Throughout this whole thing, the word officers used all the time. I don't think it means the same thing.
Right.
I think we need to define that as either just city council or what we want it to mean.
I think in chapter 7 is where we reference the administrative officers. But administrative officers might not necessarily be officers in another context.
Right.
That's correct. Yeah.
So we either need to call them employees or administrators or something.
Elected, appointed
Correct.
employees.
I think in section 3, chapter 3, the city council members are defined as elected officers as opposed to just officers. So I think.
Oh, so we keep that in mind.
So I think we should keep that in mind moving forward, that when we're talking that in 3.1, right up front, the elective officers of the city shall be the 5 council members. So elective officers kind of defined there.
And so if they say officers, it potentially means administrative officers as defined in 7 and elective officers as defined in 3.
It would be both, right?
Collectively, yeah.
Yeah, so we should, as we go through, we should delineate that on each line, which officers we
And if we mean all officers, then
put them both
Good policy.
elected and administrative.
I mean, it's probably cleaner to do it, just about you don't cross-reference all throughout. Yeah.
You know, I've worked at 4 municipalities. I've never heard an employee call an officer.
It's a little unusual.
Right, so maybe when we're talking about employees, maybe something like
Well, there's employees and officers referenced in that 4.9.
Right.
Yeah, both.
Maybe administration, please, would that be our 2 different ones or one? Guess where the police come in, the police where the courts.
So this for word administrators, they're actually an office.
The judiciary is a different animal. We didn't have a judiciary before.
Well, let's keep that in mind as we go through here. So when we get to that, maybe we'll come up with a word that we can use based on what we're trying to define in the chapter. All right, so the organization, we're on 4.4, organization of the council. It's held on a Tuesday following the regular city election. This would have to be changed to reflect what we put in 3.3. So 4.4.
Yep, so I think we say Tuesday, following the canvass of that election and strike out each city election. So we had previously changed section
3.3.
3.3 to reference that the first meeting of council shall be the Tuesday following the canvass of the election rather than the Tuesday following the election. The understanding that the canvass may not be completed by then. And so this would just be updating 4.4 to have that same language.
There's probably a very obvious answer I'm just not thinking of, but why does 4.4 only say in the event of a vacancy occurring in the office of mayor pro tem and not both the mayor and mayor pro tem?
Because the mayor pro tem moves to the mayor,
That makes a lot of sense. Okay.
Yeah.
The obvious answer I wasn't thinking of. Yeah.
they don't have a choice, they move there.
It's true, although you could make a change to indicate the mayor and mayor pro tem, because then you would give the authority to council to replace the mayor with someone who wasn't a mayor or mayor pro tem previously. And I don't know whether that's a good idea or a bad idea, but that's good.
It's a mayor for Tim, like, that's their main job is filling in.
So they can act in the stead of mayor under the charter. And we did have a circumstance because it was Jesse didn't run. So we did in the last section, the last election, we did have to elect both the pro tem and the mayor. So that was the unusual circumstance. So
And just so you know, like, some of the things that the mayor pro tem can do in the absence of the mayor is there's very few things that the mayor can do. Call up the National Guard, but they also can marry people. And the mayor cannot marry the person the mayor pro tem can do. The mayor is out of town, unable to do it.
Like a parent, that's interesting.
I just don't, in my first 8 years as mayor, I married a lot of people. I mean, I didn't marry a lot of people. I did those marriage ceremonies. In the last 4 years I was mayor, not a single one. Now the judges do it on a regular basis.
So 4.4, we're going to have that changed. So we've got that on there to Tony to do. Okay, 4.5. The he's and she's are in there. So we know that that's going to be later when we do the whole thing. Anything else in the duties in there? That really is to call the National Guard is the only thing the mayor has the power to do. That is provided in 4.5C. And
We talked about replacing change the word person. So that this person shall not have an.
yep, and we're going to do that by omnibus resolution that will impact all reference areas.
Couldn't you do for like, say, 4.5B, just the mayor shall authenticate, or rather than using persons like, yeah, she gets. You should look at it, use the title, it's he or she, it's not a title, person.
No.
There might be a few variations that make more sense for.
Yeah. The person should not have any veto power reads very awkward.
Yeah.
Yes.
or they. So can you put that in an omnibus resolution or
Yeah,
ballot?
yeah, I think that all as person or less appropriate, something along those lines.
Okay. Okay, so then we go on to 4.7.
So wait, I got just 2 seconds, because that was interesting. You said National Guard. I wasn't sure. Murphy out there with a baseball bat or, but, so is that plug into, the National Guard? Are they looking for who is to authorize? Was it,
You actually mean the police probably, right? Not the National Guard.
no, 'cause-
I'll just say that I think the state statute actually is, it authorizes the mayor to call out the citizen to suppress a riot. So it's not the national.
Yeah, I think it's Act 390, it's the Emergency Management Act, which gives the chief executive officer of the municipality the authority.
right, and it's specified, that's actually specified in emergency response processes outside the city, like US.
Okay, so we're okay with that? 4.6. Right. Meetings of the council. So under 4.7A, they pass a resolution at the end of the year for the meeting schedule for the next year. And it is a resolution. And this defines that they have to have 1 month. And I don't know if the time set for the regular meeting is a holiday, then I don't know if you needed that to have that in there because you're setting that.
The year of this.
Yeah, so you're not going to set it on a holiday, so I don't know.
I don't know why that's there. It would seem like we know what the holidays are already. And unless they established the holiday while we'd already adopted,
That in theory could happen in 2020, right, when Juneteenth was established as a holiday, so it seems fair to keep it, just in case some, things change and no need to. It's not broken, don't fix it.
Well, and it sounds to me like if, they say, okay, we're going to meet on the second Tuesday or the, alternate Tuesdays, and, if Veterans Day is one of those floating holidays, and if it hits that, so I think it's not a bad thing to allow that.
For this, which holidays is it referring to? Like, is it all federal holidays, state holidays, or
I think it's open
just all
for
holidays?
discussion. For the council members to decide rather than, religious holidays are we going to start because they keep, we keep finding out more different holidays than we ever thought that there were, depending on who celebrated them. So if you just leave it generic, it'll be up to them. I think we're sort of aware of what's on the calendar.
yeah, just say that, the second sentence that sort of mandates that it's the next day. But though we set it for Tuesday, it would just seem like council at its next meeting would be scheduled that, and we would know in advance anyway. So I'm not sure that that's this automatic going to the next secular day, whatever that means, would be necessary. That's language probably from 1948.
That would be celebrating Christmas, and the next day was Christmas. Christmas Eve and Christmas Day, they're both considered somewhat of holidays. To some people, I guess.
The Boxing Day second.
But could we do something like, the time set for a regular meeting is a holiday, then such regular meeting then council shall reschedule such regular meeting at a date and time to be determined?
I just go back to the city administrative secretary, administrative assistant prints out the proposed days with the city manager's input. They print that to council and then they vote on it, and none of them are on a holiday. And if they cancel one, they cancel one, and if they create a new one, they create a new one. So really, that whole sentence doesn't really matter, because if they find out later it's a holiday, they just cancel it. And then they schedule another meeting based on what are the requirements as we go further on.
Right, sometimes first, they're earlier in the month to make sure.
Well, and I think this sentence likely predates the Open Meetings Act obligation to pick your regular meetings for the year in advance of the year. So that's the resolution.
So we can drop that whole second sentence,
I think it could be just,
deleted.
yeah.
All right, for those of you who are watching, we had a little technical difficulty. We've moved to 4.7. We just had a general discussion about that. 4.7 A through E. There's just discussion that that's just basically what's in state law. We're going along with that. No changes to that. We're on 4.7 F, and I'm just talking about who is signing the minutes. The process is, this is going to come up later because there's this 15 days in later parts of this charter. You have the meeting, a person taking the minutes writes them up, and then at the next meeting, they're given to the mayor to sign, and then they're signed by the person who took the minutes as well. So they're not signed immediately because nobody's taking the minutes right away because you don't have to vote for them. So sometimes it's more than 15 days because you might not have a meeting. We used to, you know, when this was done, they had meetings every week.
Yeah.
It was the first and the third were their business meetings, and the second and the fourth were discussion ones. They could do some business, but it was more like appointments and things like that. But the public hearings were on the first and the third Tuesday. So now they've changed because times have changed a bit. And so they don't have a regular schedule other than what they've approved with that resolution that we talked about in 4.7A. And so I don't know when we get to this 15 days and things like that, just keep that in mind. But for right now, I know the clerk is not the person that's always signing.
Was that the thought that the clerk was responsible for the minutes and would have been the transcriber and
They've been at each meeting.
so now it's a different role?
Why isn't, you know, sometimes she's there.
She's not taking minutes, it's general.
She is there.
So the clerk or
The deputy clerk or the clerk?
Say that again. The deputy clerk, did you say?
The deputy clerk or the clerk are taking minutes. So whoever the clerk's designee is.
So that would be
So
the thing to put in.
if there was a change here, it might be the clerk or the clerk's designee, but I think we need to know whether this is actually part of the state statute.
No, I don't believe so.
Yeah, because I feel like that the council has had this discussion previously about the clerk, the actual clerk. Required to do it. You might look at our operating procedures. You might make reference in the minutes to the clerk or a designee. But just by the charter, it should be a clerk charge. I don't know.
Yeah, I'm wondering if it's something that required to change or if it's just a policy change that we have the clerk actually sign it. Because if there's nothing here says that the clerk has to be the one taking the minutes or recording the minutes, or even that the clerk has to be there. So it seems like council could just, once it's approved the minutes, send it to the clerk's office to have the clerk sign it, as opposed to any other,
Yeah,
needing a change and going through the whole process.
because every resolution, whether the clerk is there or not, is signed by co-signed by the clerk of the mayor. So,
Yeah. But the minutes are not being.
right.
So do we change this to accommodate what is being done? It's a question of whether we change what's being done.
Seems like it's more important to have whoever's taking the minutes sign them, because that's a representation that they're accurately representing what transpired at the meeting. Having the clerk sign them, it might be an accident. How would she know whether it's accurate, or he or she know? It would seem to me that it would be more appropriate to have whoever was recording the minutes. I know.
Well, it also gives the person, without having to go into a video of the meeting, it would tell you who that person was that was at that meeting versus,
Generic.
yeah. So the clerk or the clerk designee, but then the last sentence too on this, this old fashioned before we have electronic stuff. And so you might say, since we're changing something in this section, we should probably do something just by saying all minutes and records of all regular and special meetings of the council will be posted electronically. I mean, what's the most generic thing, knowing that the world may change in the next 10 years?
I think it's a,
Under the Open Meetings Act, 15.269 sub 2, that's where that comes from, and it's still that way in the state law.
yeah, I think it's valid because you don't want to stay available 24/7 if you've got a around in chat.
You need the last 3 words though during business hours.
Yes, I think you do.
Diane, is your question whether it should be, I mean, it sounds like what Tony's saying is that it can't be changed, but it's required by state law that it be.
Well, I mean, we will still, I guess, we will still be obligated to do it under state law. We could change it.
But
I would recommend we keep it, and then we also add and shall be posted electronically. And there should be a physical copy available, because not everyone has computer
that's
access.
what I'm saying.
But making a requirement that be posted electronically also keeps up with the precedent.
Should that be a requirement? Should it
I
be
think so.
available? Why is it a requirement to be posted? And what if there's technical issues? Who's required to resolve them?
We have to post it. If we just say it shall be posted electronically. And
Where are we posting electronically? I think that really gets muddy. It's also by posting it on the webpage or whatever, we're making it available and accessible. And that's right, what we need to do. And so, yeah, I don't know. I rolling tech in, I think that's a mistake, is text changing all. Where would we be posting? On our
Probably
website?
the website, right? And where's everything else get posted?
Right, but we keep it website. If the recommendation we make is that we keep it vague enough that it just has to be posted somewhere electronically, then that leaves it open. Times evolve. And I don't know, we don't know what's coming next. If websites disappear and everyone's using the city TikTok now, like,
Well,
it could still be.
Yeah, my concern is that you lose a hard copy.
No, I'm not recommending that. I'm recommending that we require the hard copy and additionally require an electronic copy.
But if we say it's available, then it could be digital, it could be wherever, the media doesn't matter if it's available.
Well, in theory, it would be great if people could access stuff outside of business hours electronically.
They usually can.
Research.
I think that's great. It's important whether on mandate, sure.
Okay, I
Yes,
think
yes, actually, it's important.
two of you
Yeah,
are,
why?
what's being argued here.
We're talking about adding a requirement that it be digitally posted.
Yeah.
In addition to being available. So I say it being available, yeah.
I mean, we talked a little bit about like throughout this charter, if there's a way to increase transparency and make information available to the public. We should probably try to do that. I think,
I strongly agree.
so if there's some generic way that we deal with any of these issues that makes it available to people,
I totally,
figure out the stand what that is.
yeah, and I think it should be accessible, available. I don't think it needs to be available outside business hours. I think it has to be available during business hours. And so the electronic version is a bonus access. That's what and that is a practice. We put it on the website, whether or not.
I think that's kind of discriminatory if you just say during business hours, because people are working days. How do they get to this? I mean, we're a 24/7 operation in this world now. And everybody should have access to this depending on what their lifestyle is. I mean, I would never be able to look at the minutes if they were just at the city website on a 12-hour shift. I'm just,
Or if you had to go pick up a hard copy.
yeah, and we always, later on, we talk about posting at the library. The library can be electronic, anyone can get on it, anyone can print it from the library, so you have a lot of.
If they're sitting at the library computer, but they have so many people that have no access to computers except at the libraries.
So would it be okay to say that any person shall have web access, to minutes, et cetera? With and strike during business hours.
I think the state statute actually has the business hours in it, so don't keep that. I think you want to add.
Yeah.
Yeah.
So you can add something like, and the minutes shall be posted on the city's website. I'm assuming that we're always going to have a website now.
That's.
In the future committee, keep 10 years from now, say, we're no longer websites.
How about the future committee says this format is no longer supported and you have no other choice but to use this format at this cost? Your website will no longer function, you know.
We can say post electronically if the website's too specific.
Yeah, that's fine.
Yeah.
Sure. Access. Yeah. Yeah.
So
The blanket.
while we're messing with this one though, any person shall have access to the minutes and records of all regular and special meetings of the council during business hours. Doesn't clarify that we're talking about hard copies, even though we're obviously talking about hard copies.
Yeah.
So we should, if we're already recommending a change to this, we should just make it clear any person shall have access to the physical minutes and records of all regular and special meetings of the council during business hours, I would think.
Or why don't we echo the language earlier and have to the minutes or the permanent journal of all regular and special meetings. And that way it goes back to the earlier language there. So then we're talking about something that's permanent and then adding the language about the website.
That's
that.
Second line says permanent journal. I mean, that's really what it is. It's a binder. Here you are. And that's the way the zoning office is the word. We go down there, they show you assessments or something like that. You want to visit.
The minutes of in the permanent journal.
So then read what you were saying.
I think I was looking at maybe, any person shall have access to the minutes in the permanent journal and records of all regular and special meetings of the council during business hours. And then we can add, minutes shall be posted, shall also be posted on the city's website.
Yeah, like that also, so we make sure we codify the existing.
Sounds good.
Yeah.
All right, we're all okay with that. Sure. So it's just saying whether we, here's where we have the police shall serve as the sergeant of arms. Here we have misconduct. And Mark, do you have any specific history of this? Because you modified it a little bit. You pulled it out to have a separate thing.
Again, what are for other officers of the city?
The language about the police chief being sergeant of arms, I think the charter that was worked off of whatever 40 years ago or so was the charter that was passed in 1948, and I think we just kept all that language in there. So while the chief of police, we might want to change that just to identify that a police officer or someone designated by the chief of police would be the sergeant at arms, because the police chief isn't always at these meetings, although there was a period of time when they always were. But there's generally a police officer present in the audience that can serve as if there's trouble, basically. So I think you can modernize that language a little bit to let somebody be the designated sergeant at arms. I don't think the council wants to appoint that person, but certainly the police chief or somebody from the police department can serve in that capacity.
So the chief of police or designee.
Yeah, well, this is for the purposes of this section, so this would be if two council members make a motion to compel the attendance of another member, then this theoretically gives the chief of police the authority to arrest that person. Well,
Bring to the meeting.
yeah, to capture that person and take them to the meeting. I think this section should be, this sentence should be deleted because I don't think that's the thing.
I want to see a movie where that happens.
I mean, that's.
Like kidnapping. Seriously, yeah.
I mean, it's at the very least an arrest, and the council doesn't have that authority.
Yeah.
So, I mean, we can,
Does it at the same charter extent the council has that authority, does the city council have that authority?
I mean, that seems to be a constitutional issue.
They want that authority.
Well, this is also a definition of misconduct in office.
Which,
Yeah,
And it's contained right in there. So, I mean, you gotta make a decision as to whether you want this here or in the other misconduct provision. But see, the fact that the chief of police has this is limited, apparently limited power to only enforce this section. That's sergeant at arms. That means if you want to look at it. Like I say, the chief of police or the designee could be the sergeant at arms at every meeting now. It shouldn't be limited in terms of authority. Here, it should be a general authority to operate, to keep peace within a council meeting.
do we
And I
need
think
this at all?
Well, so I think we're having two different conversations. I think what Mark's talking about is whether we want to have something in the charter specifically about who shall serve as sergeant at arms at council meetings. I think we can kind of earmark that and come back to it. As to whether this is a ridiculous situation we're talking. We're two council members for staying, we're compelling everyone else's attendance and
can direct the chief to kidnap.
not kidnap, because I think by being a city council member, this would be what I would argue if I were to make this ordinance or this provision. By agreeing to be a member of city council, you are agreeing to the city code, which means you are agreeing that your attendance can be compelled by force of law if two members say so. So I don't think we have any constitutional issues, but don't quote me on that. But I think that we should look at whether the misconduct in office thing here. I think to what Jeff was talking about earlier, it really flags that, in 3.4, we talk about conviction of. Here it says that a member who doesn't conduct himself in an orderly manner shall be deemed guilty of misconduct in office. There's a real deemed by who issue there. And I also. Yeah,
It's also an attendance thing, but we have an attendance provision that deals.
Right.
Right.
It's under two attendance. I think you got a problem with potentially, compelling someone to force it. That's, this has happened in other states where like half the legislature, they'll leave. And they will send out like, supposed officers to bring it back or whatever. There's gotta be some better answers on whether that's, what do other charters, Johnny, that you're aware of have similar provisions to this, and it's not been used anywhere that we know in the state of Michigan.
I mean, I've seen a similar charter. It was probably in the model charter sometime decades and decades ago, but I don't think I've ever seen it imposed, because just like I was talking about in the other community, and said they just don't show up and you kick them off. I mean, other than arrest them and make them show up and be like, you will vote.
Well, except that maybe like in the Texas situation where it was to avoid vote. So that was their action, was to not show up at the meeting, so they didn't have a quorum, so they couldn't take a vote. So.
Yeah, I think that, here you have a situation, whether it's a special or regular meeting, or this, that two members show up, there's no quorum, and there's an important item that needs to be passed. So you need to have the authority to actually at least get one other member there. Even if they vote no, got the two votes to, get something passed. And it's like, I don't think this is a bad provision. I'm not aware of it ever being used. But I have more of a question about the fact that it's misconduct in office, quote unquote. And then, in the next one of the next sections, we have that again in investigations and requests for information. But now the real definition in the charter of what we're talking about here is one thing to say, oh yeah, it's a conviction of a felony, But this obviously has a broader meaning than that.
Guilty to me, that sounds like a crime, but it's not, unless it's, code of ordinances somewhere, is it? Yeah, I mean,
I don't think it's a crime, because it's just misconduct in office, which is specifically defined 3.4. So it's not a misdemeanor. But it's, attendance at a meeting, thinking about, this is really in the mind of the law, it's like direct versus indirect contempt. But attendance at a meeting, we know whether someone's at a meeting or not. That's not something that needs to be determined by any group of people. Whether someone's conducting themselves in an orderly manner and making that misconduct in office, which makes it a removable offense.
Yeah.
And again, I just ask, deemed guilty by who? And that's not clear in the provision itself, which creates a big issue when we're talking about this being something that makes someone removable from office. So.
Well, it goes back to the language that you guys, I think, are taking out, which is, but not necessarily limited.
Yeah.
Because that then incorporates both of these provisions and makes it an automatic removal from office. If that's not what you think should be done, then we can refigure how this could be impacted. So this goes back to the ability of the council to take action to judge the qualifications of an individual. Maybe it's better in that section to make reference to these two sort of outlier misconduct in office.
Well, but so within 3.4D, misconduct in office is defined as, and then 3, conviction of any act committed while in office which constitutes misconduct in office under other provisions of this charter. And so that's how this gets brought into it. The issue is that I think that be deemed guilty of, it doesn't work. I think that needs to be replaced with shall constitute misconduct in office, because you could then be charged with it where there would be a conviction, which would then step forward section 3.
conviction is like criminal in 3.4D3, but these other things aren't necessarily criminal. Same thing with 3.13, pecuniary interest. So if someone doesn't disclose a pecuniary interest in misconduct in office, they can be removed from office, but is that say things that there says they shall be guilty, not be guilty. So things just got to be somehow made the conviction for it should be in there. Or there needs to be another subcategory that misconduct's all these other.
I think conviction is the wrong word. I think if you wanted a determination that someone has committed misconduct in office, because conviction means they were found guilty by a jury. That's what conviction means.
Who makes the determination? What's the standard?
And that's a whole
council. Is it 4/5 of council?
It's only the two that.
But I think that, what Diane's plan as of now, which I think is a good one, is to just earmark all of this, because we're going to run into misconduct in office a lot, I think, as we go through the charter. And I think we don't need to make a decision or determination tonight, but I think it's something that we really need to be thinking about, because it has such importance and it has removal authority as to what such a process should look like, if such a process should be processed.
And we can go with the constitute, placeholder for now.
Yeah.
Fair enough.
And, when I'm reading this, the sentence that says the council may enforce orderly conduct in the meeting, that next sentence could really be deleted. Because the next sentence after that is the chief of police shall serve as the sergeant at arms, et cetera. So why do we need to say that any more strongly by that sentence? Orderly shall be deemed guilty of misconduct in office. I don't know if that's necessary.
It would only be necessary if we wanted if the purpose the purpose of that sentence is that it makes it misconduct in office, which makes it removable. So I agree with you. We determine we don't want that we don't think that should be part of the charter, a removable offense. We should just pass it all together. We determine that we think it should be a removable offense, as it is right now, somehow, because we don't know how the mechanisms would actually work. Then it's something.
Is there any way, and I think someone mentioned this before, that we could you know, if there's a pattern of behavior that the council deems unacceptable, if you know what I mean, if you have someone that's continuously disruptive or, you know, if we remove this, is there any way to deal with that? If it keeps happening.
I mean, I think something that we might want to think about is as we collect the misconduct in office, as we go through the charter, is making a non-inclusive list of what misconduct in office isn't just sticking it right in 3.4. Yeah, and so, and then, so as opposed to having it be listed throughout the entire charter, just have it right in 3.4D, have it be a non-inclusive list and lay out, you know, a misconduct in office as defined by board, as determined by board bids and council. Would be my like preliminary idea to make it, it has to be unanimous with everyone else.
Yes, yes.
All right, so then we're gonna have 3.4 and 4.79 instead, we're holding those. And we'll add more as we go along, because we'll also deal with that. In that one, we'll also deal with the task and officers, so we'll have that discussion. We'll try to put that together. I think it's getting late. It's 9:04. Do you want to finish chapter 4, and then stop, and then we pick up 5? Do you want to keep working through them? Okay. You're staying. Did you have anything that you wanted to say at 4.8 before you went?
Yes, no, I don't.
You'll have the chance when you come back here too. So, okay, so the 4.81 is restriction on the powers of council.
That's 4.8. It's just the way this, the footnotes and how it got turned into. That's the one from the footnote that it came down into it. It's actually 4.8.
Sorry, okay. So it's 4.8. And so A is what we talked about. Council doesn't have that power to contract with them. B is the selling of the land, and D is that everyone has to remember that if they're having an ordinance, you have to have 3 affirmative votes, and can't, if you have 3 in there and somebody, and you go ahead with the vote, if someone doesn't defer it, I mean, because they know it's not going to go through, your ordinance could fail. So that's a council process that they have to be aware of. And then there shall be no standing committees of the council. Can you do something to define that? We talked about that. I'm not sure if you're here, but just a definition of what a standing committee. I don't mean not a standing committee. A committee can be formed that has a purpose with a designated beginning and end or something like that.
Yeah, because I think that it is always referred to, you know, it's of the council. So it's like if we had a finance committee with 2 members who would meet with the CFO and figure out where we're going with the budget, that would be a standing committee of the council.
The council. I think that's a really good point.
And so that's what this is really referring to, not our boards and commissions.
Right.
This is not a standing committee, but this is a committee of the council.
It's not standing because we've got to stop and
Purpose.
Exactly, a purpose that.
Purpose with the beginning.
So I don't know how you would define that to make that clear, but, you know, this is the old language and, you know, we kept it in there. I'd say they're also, B, I can't remember whether it was Jeff. Who brought up the issue, and then just Diane, I was on council when there was a change here to go from the 60% or whatever it was to the simple majority to sell property of the city. But maybe you could talk about why that change was made. I think that change was made at a special election, maybe 10 years ago or something.
2015.
To
increase the value.
No, I mean, the movement to majority from 60% of the population.
So what, that want to sell patriarch or?
A simple majority.
Or do that, it should be higher.
They just felt like everything else, we don't have anything that has to pass on a ballot. That's with a simple majority. Was never really a discussion that this could be the way people have it on the ballot. It's treated the same way.
I think Jeff's point in his email about it being a non-recoverable asset is important.
And something, yeah, it's like permanent, some things can be contentious, so if you have a higher minority, you know, like the community has really decided to do something. I'll just use an example, some people really kicked off and paying farmers. Even if 51% of people said no, you know, sell like 49 might be free. But, you know, 60% or 2/3, and there are other times where, think of Congress, I guess, where things require higher threshold to vote on something, so I don't know, just one of those things that thought maybe for discussion, up to.
And I think like in a lot of communities, I see the either an absolute prohibition on selling parkland or something similar with the supermajority. But some of the other things here, you know, just as a point of reference only, again, not trying to inject any policy in it, but for example, we were just meeting with the broker for the DDA and selling the Upper Green properties, which are 341, 343, 345, I think. And those are just southwest of City Hall, southwest of City Hall behind the MSU FCU building and across the street from the Graduate. And so when we were talking about like a more cohesive development, that's a fairly large parcel, but it also using the right of way we have, which is where we actually cut down a portion of Evergreen, it goes all the way over to the city parking lot. It's parking lot 12 that comes off of Abbott. It's right across from City Hall. And so we said, there's a possibility. He says, wow, look at for a big development, we could buy this Hagen property that's kind of in the middle of all of this. But then we have this huge piece that comes off Abbott, you know, that in the parking, there's an ability for a parking structure at the bottom. It will come off Abbott, come into this, like that. This is a game changer. This is a huge deal. And we said, yeah, of course, this is city property. And so we'd have to go to a vote of people to allow that piece of the project to happen. And he was like, I forget about it. Like that's, you know, because they would have to be all the way at having a site plan completed, including that property. They'd have to have already bought the neighboring Hagen property. They'd have to be so far down the line. And then I know there's history in the city, Mark will know about it, and actually Dan will know about it, where they have gone through all of that, expended a huge amount of money. Then it gets on the ballot. The development itself becomes the question and what's really politicked over. People say, we don't need this huge development across from the Graduate or whatever it might be.
So, because the Evergreen's already owned, right?
It's owned by the DDA, but the city property is parking lot 12, which is across, it's on Abbott across from City Hall. And so, so there have been a lot of communications internally that this provision hinders economic development that includes city properties. So I was going to say that, Mark, I don't know.
Yeah, no, I think that was the motivation actually for and that was a special election, but in May, even though the issue, the vote, I thought was in January, but the vote of the people on that was just like barely not 60%. I can't remember the actual vote on it, but there was a development that ran all the way along there. And it failed because there was no proposal to sell the city property because it included I think a senior housing project on what is parking lot 12. And that's not the reason it failed, but that included that. And since we couldn't sell it, you know, the whole deal fell apart. Ultimately, you know, we had other developers come in and talk about that property, but just put it on the ballot. Remove that 60, I thought it was 60% requirement and make it a simple majority.
3/5.
And it's important to remember the people of the community voted in favor of reducing that to 50 to a simple majority. So the public voted to change this provision, the higher provision. You know, I agree, you know, there's at some points, especially when you're talking about parkland, not parking lots, that I have a little bit of an anxious feel about having it a simple majority But you could argue, you could change this, say, for, city-owned property that is not parkland, or something like that.
Yeah, I guess
And the other option, and what should have been said to this other developer is, the city will lease you the property.
100-year lease.
And depending on our city attorney, we've had city attorney who said, hey, it's okay to lease it for 100 years. And then another city attorney who said 49 years is as far as I can go, but have a renewal. So I'm waiting to hear what Tony has to say about what we can do. But when you tell a developer, yeah, you can lease it from us for 100 years, then, and you're paying taxes, then they're more likely to go ahead with their deal.
Isn't that what they
It's
did
just
with lot
another
one?
business part of it.
Isn't that what they did with lot one?
Lot one is a 49-year lease with a 49-year renewal. And
I guess,
that property took, I know, I end up defending this all the time, but we went from $435,000 a year in revenue from that to over $1 million through that.
and we lost all the festivals on the parking lot and the pressure on the bars. But I get it, but I guess my thought is, I like the 60, but also, okay, I guess I don't see a lot of East Lansing development being held back. I feel like we've been building. I hear what you're saying, and maybe it's not easy. And I also came across, and I'll send this to everybody, after the meeting that Ann Arbor has just reopened their charter to make a land development change. And exactly, to no longer require supermajority so that they can approve development after the site plan is approved automatically. And I know we're going through a new planning study and plan, and I know that the planning director told the Bailey Group that they hope to be able to do basically the same thing where it's such a great plan and it's so well articulated that they will not have to go for votes, but
Yeah, I will say, I'm not familiar with what Ann Arbor did. I know they just passed a provision to encourage renewable energy within the community and do it within the development projects that they had. But,
well, this would
You need
simplify the
to-
process of removing the requirement for the supermajority.
every provision should be here to encourage public input. And when you shorten the process, I get a little concerned about that. Want to make sure that the public has a right to weigh in and do it in a vigorous manner.
Are there any cemeteries in the city?
Yeah, I don't.
No, we are allowed to have one though. So,
Okay, I was curious, that's
Yeah.
like a relic, it's in here a bunch of times.
yeah, that's one of the relics.
But we have a lot of land up there along the highway that we now own, so.
Who knows?
Just put a cemetery in. Yeah, I mean, this is for that land.
Great cemeteries.
So,
Jump for that.
Throwing this out, but could we get rid of the dollar amount and say all buildings or parkland have to be voted on? To give the ability to do stuff with parking lot?
you have to have a dollar amount in there because sometimes it's just a tiny little
Right.
piece, like a corner of a street. You just want to move the curbing over and you don't, that's city property and you want to give it to the developer and they're exchanging something else. It doesn't rise to that amount that triggers that you should be going to the voters to say.
I think Joe was saying,
Yeah.
I think Joe was saying rather than have it figured by a dollar amount, it's a piece of property owned by the city that's used as parkland and or a piece of city owned by the property that has a city building on it.
Correct.
Yeah, we had this happen, actually, the project across from Crandor, there's a street there right on the city border. And we had a little sort of like a cul-de-sac that needed to be part of that project. And we exchanged actually property. They gave us the property that they had on Kalamazoo, the Lansing did. And then we transferred that property. It wasn't worth $4. It was under the dollar amount, and we were able to take care of that right away.
I'm just saying, instead of any real property, we could actually define it into parks, buildings, whatever else we want to add, which would leave parking lots as something that could be sold. That's something if we we're interested.
Except that that got very controversial, I think of the lot behind Peanut Barrel and that. And so that, people love that parking lot apparently, so, you know, that.
So we table this for next meeting, just, yeah, so you get out this. Shut it short.
Okay, so we'll start with,
Yeah.
we'll start with 4.92 to discuss that one, 4.8B and 4.9.
I'm gonna miss the next meeting. Something I want to talk about, 6.6. I don't want to open a can of worms. I just want to add some minor input. Before, so I'm not gonna be here next time. 6.6, Jeff had included in his email about the enforcement mechanism for the code every 10 years. And you would recommend sunsetting ordinances. I just wanted to point out, this actually might be for Tony and Mark as well, that the city code currently doesn't have a savings clause, which means that if ordinance is sunset, and if there's anything pending at the time that an ordinance would sunset, that such as a prosecution under a certain ordinance, then that prosecution can no longer proceed.
That's would be very inspiring.
So a few years ago, when the city overhauled its disorderly conduct ordinance, which Mark, I think was after you were no longer on council in 2020.
Right.
When that overhaul happened, the city lost a number of prosecutions that it could no longer proceed on. Because the savings clause, because there was no savings clause, and so those ordinances were gone and prosecutions were gone. So that's something to keep in mind if we're considering a sunset clause for ordinances generally. So just one add my 2 cents there, so I won't be here next time.
All right, so what I would summarize is, so our, Asia does our agenda. So our, we're gonna turn around and put our old business first before our new business. So our old business will have on here 2.2 review and 3.6 review, 4.4, 4.7A, 4.7F, 4.8D, 4.8E, sorry, E and
B as in boy and D as in dog. 4.8, B as in boy.
Yes.
4.8 B and D, 4.8 B and D, and then 4.9. That'll be our old business. We're putting, after all of that, on our old business, just hold on 3.4, 4.79, because those are our misconduct ones. So we can keep tabs of that. And so then we'll start with chapter 5, 6, and 7 will be our new business. I guess you have to put chapter 5 and 6 as our old business, because that'll come after we review the stuff from Tony. So after all those little ones, I said 5 and 6 will be our old business, and our new business will be chapter 7. For John,
I still move.
by Dr. Otis and seconded by Mr. Gordon. All in favor, say aye.
Aye.
Aye. All opposed, same sign. Thank you, guys.
Second on the right.